your screen, and you should see some little emblems. One that says enter full screen, and right next to it allows you to pick your view. So you can have a gallery view where you see everyone's little thumbnail. So if you'd like to focus on Jan, if you click speaker view, you will see her when she starts to talk. She'll pop up in your main screen, and you'll see everyone else at the very top. And there's a little arrow to scroll through everybody if that helps you too. If you want to see others that will speak. Is someone doing a share screen right now?
And why?
Is that Jan's?
Yeah, I'm having a little.
Okay,
Yes.
just checking. And also you can also choose to pin Jan. So if you scroll through all the different thumbnails of everybody, you can hover over Jan Rein's picture and click dot and click pin. And that way her screen will be up the whole time that she is speaking. And when she shares her screen, you will see that as well.
Sabrina, your microphone seems to be creating a lot of distortion. Perhaps if you're a little closer to it and speak more softly, it will work better.
Sure. Is this better?
That was much better.
Okay. So let me introduce Jan. Jan Rein graduated from Georgetown University Law Center in 1965. Her first legal job was as a staff attorney, legal aid, civil division in Harlem, New York City. In 1976, she began her 30-year career as a law professor at several law schools. She has been an activist her entire adult life, and for the last 9 years, she has devoted much of her legal research, writing, and time to promote Move to Amend's proposed constitutional amendment, which abolishes all so-called corporate constitutional rights. She is a member of Move to Amend National's Law and Research Committee, which produces materials to educate the public about the devastation the court-invented doctrine of corporate constitutional rights inflicts on individuals, communities, the environment, and our democracy itself. So without further ado, I introduce Jan Rein.
Thank you, Sabrina, for that terrific introduction. And thank you, Ellen, for doing the recording. That takes a lot of preliminary work. And thank all of my compatriots at WILPF and Move to Amend for doing the publication necessary to bring people out so that I won't just be talking to myself. Greetings, fellow activists and concerned citizens. I want to start with a question, a virtual question. How many of you are frustrated by the spectacle of seeing the policies and reforms that you want being overturned, watered down, or never enacted in the first place? I am mentally imagining you raising your hands, and I just have to say that I agree with you completely. I am always frustrated by this. It all comes down to corporate rule, which both scares me and also makes me angry enough to devote much of my time and energy to doing legal research and writing and talking to educate the public about the illegitimate doctrines that enable corporate rule. In fact, they promote corporate rule, not just enable. Move to Amend's educational goal here is to inspire a massive people's movement, strong enough to rip out of our Constitution these illegitimate doctrines. It has to be ripped out root and branch. So this talk is about the root causes of harmful corporate rule and the structural change We need to end it so that we can create a democracy that is truly accountable to us, we the people, not to corporate interests. Move to amends, we the people amendment strikes at the roots by emphatically saying that only human beings have rights under our Constitution, only human beings have constitutional rights, and that money is not a form of protected speech under the First Amendment. Move to amendment is the only one that ends both the doctrine of money is speech and the doctrine of corporate constitutional rights. There's a lot of other proposals running around, but none of them does both. They either do one or the other. And we want to kill the beast completely. So, not literally kill, but you know. Anyway, most people already know about the Supreme Court's decision in Citizens United that put on steroids the legal fiction that money is speech under the First Amendment. I'm not going to talk about that because most people already know about the harm done by the Citizens United decision, tsunami of money in our politics. I'm not going to talk about it except to say that I wonder if I could spend some money to get more than 2 minutes to speak at a city council meeting. I don't think so somehow. Now, I am going to talk about something that most people know absolutely nothing about. And that is the harm caused by the Supreme Court's invention, literal out-of-the-air invention of corporate constitutional rights under the 4th, 5th, and 14th Amendments, and other parts of the Constitution, including the non-money is speech aspects of the First Amendment. Let me follow up with another question. In a democracy, who's the sovereign? Now, I am, again, mentally imagining people saying, we the people. And you would be absolutely right. We the people created government, and we the people created corporations. So the We the People Amendment is not just about policy. It's about the principle of self-government. It's about who should decide whether or not a polluting factory is going to be placed in your town. Should it be you who live there? Or should it be some multinational behemoth corporation whose board of directors lives in luxury far away and will be completely unaffected by what's going on in your town? I always cringe when I hear people say we should have a seat at the table. We own the table. It's our table. We should be the ones to say who sits at our table and what they should do while they sit there. So no more asking meekly for a seat at the table. We own it. Now, I'm going to starting to get into, excuse me for just a minute. I'm starting to get into the harm caused by the application of the corporate constitutional rights doctrine. So a little background here before we get into the cases. For the first 100 plus years of our nation's history, corporations had no constitutional rights. But starting in the late 1880s, the Supreme Court literally invented out of thin air so-called corporate constitutional rights. Now, I want to explain that a corporation is an artificial vehicle to accumulate capital and to do business. When courts give constitutional rights to a corporation, they are giving constitutional rights to property, not to people. So this is like the sci-fi movies that you see. I love sci-fi. Anyway, you see these sci-fi movies where the human beings create the robots, and then eventually the robots take over and rule the very human beings who created them. That's what we have here. Would you give constitutional rights to your lawnmower, to your hammer, to your computer? I think not. These are tools. And corporations, they are inanimate, artificial tools. And corporations are tools in more ways than one. And, but they don't serve us very well when they wield their so-called corporate constitutional rights to wreak destruction on human beings and the very planet we live on. So court-made corporate constitutional rights allow corporations to undemocratically impose pollution, water contamination, environmental destruction, and other assaults on unwilling individuals and communities. All of this is in derogation of self-government and democracy itself. We always talk about local self-government. Well, that doesn't happen when the corporation rides in with its corporate constitutional rights. I call this the constitutional right to do harm. These harms fall most heavily on poor and marginalized communities. You don't see any toxic waste incinerators in affluent white suburban communities. And these harms disproportionately affect people of color and our youth who are most threatened by climate change. Time and time again, corporations have successfully challenged the constitutionality of local, state, and federal laws and regulations that were enacted to protect the public health, safety, and welfare. So now let's get into the case law. The first case is a Fifth Amendment case under the Takings Clause. In 1922, in Pennsylvania Coal Company versus Mahon, the Supreme Court struck down a state statute to prevent the sinking of homes and public structures from coal mining underground. So the court said that the statute violated the coal company's constitutional rights under the Fifth Amendment Takings Clause, which says that private property should not be taken for public use without just compensation. This set a precedent for future takings cases. Now, in a takings case, if the statute is not overturned or repealed, then the government, read you and me, the taxpayer, we have to pay the corporation all the profits they would have made had the statute not been enacted. So what community, city, town, state can afford to pay all the corporations unrealized profits for God knows how long? Obviously, this has a chilling effect. So there have been cases in which some communities have enacted ordinances to ban polluters, whatever. They've enacted statutes or ordinances in the case of cities and towns to ban, toxic waste incinerators or whatever the case may be. And then as soon as the corporation comes riding in, waiving its so-called constitutional rights to avoid the legal bullying from a corporation with its fleets of lawyers and unlimited resources, these communities have turned around and repealed the statutes or ordinances that they just enacted because they just know they're going to be slammed and bankrupted if they try to go toe-to-toe with these behemoth corporations. That's not democracy. Okay, so this is not just about the cases that actually reach the courts. It's about the statutes, ordinances, regulations that are never enacted in the first place because the communities don't want to risk taking on these huge corporations. So this is obviously not good. The next case, actually a series of cases, involve the Commerce Clause. Now, these are not cases in which the corporation is claiming a violation of a specific constitutional right. Instead, these cases illustrate how corporations use other parts of the Constitution, in this case, the Commerce Clause, to avoid being regulated. So, in City of Philadelphia versus New Jersey and other cases, the Supreme Court, having found that toxic waste transport is interstate commerce, they've used the Commerce Clause to invalidate state and local laws that sought to ban or at least limit the importation of toxic waste for disposal. So this is this is very dangerous. Children have actually died from running through fields contaminated by toxic waste. And I don't mean they died eventually. They died the very next day. So that's not a pretty thing to think about. The next case is a Fourth Amendment search and seizure case. In Marshall versus Barlows, the Supreme Court used the Fourth Amendment unreasonable search and seizure clause to end surprise inspections by requiring a warrant for the inspector to come in. Now, before this case, inspectors showed up unannounced. The result of this case is that attempts to protect the public from dangers stemming from commercial activities, for example, food contamination, drug impurities, safety hazards, and environmental hazards, attempts to protect the public against these are thwarted by removing the advantages of surprise inspections. So now, once the food processing plant, the drug manufacturer or the factory gets the warrant, they run around and cover up, they hide or temporarily remove the dangerous condition. And then as soon as the inspector leaves, they go back to business as usual. So another bad outcome. The next case, and the final one I'll be talking about, is a tobacco advertising case. And it involves the First Amendment, non-money is speech, free speech. In Lorillard Tobacco Company versus Riley, the Supreme Court invalidated a statute passed by Massachusetts that banned the advertising of certain tobacco products within 1,000 feet of schools and playgrounds. The tobacco company challenged the ban as unconstitutional under the First Amendment free speech clause. This case pitted the children's health and the state's substantial interest in protecting the health, safety, and welfare of its citizens against the tobacco industry's motive to maximize its profits by addicting children at an early age so that they would become lifelong customers. The Supreme Court did find that the state had a substantial interest in enacting this ban. Despite that, the court went on to overturn the ban on the grounds that the statute was not sufficiently narrowly tailored. So we know two things from studies. One, that children's tobacco use increases in response to tobacco advertising. Think Joe Camel. And that tobacco use, especially in children, can bring about long-term dire health effects and eventual death. So what happened here is that the court failed to weigh the relative importance of the competing interests. The result was that the court elevated the court-made requirement that the state statute had to be sufficiently narrowly tailored over the children's right to health and life itself. The children lost, worried parents lost, common sense lost. Note that the court has extended free speech protections under the First Amendment to corporate commercial speech, despite the fact that corporations neither had nor needed free speech protection for nearly 200 years. These cases disregard the legitimate interest and indeed duty that state and local governments have in protecting the health, safety, and natural resources of their people. Now, even though I'm not going to talk about other specific cases, I do want to talk about, just very briefly, corporate constitutional rights and climate change. Our three-person legal team is currently drafting an educational installment on corporate constitutional rights and climate change. It's not finished yet, but I can report that even though the fossil fuel companies can no longer deny the science of climate change, they are at this very moment using their so-called constitutional rights to make the climate crisis worse and to avoid liability for damage already done. To date, oil companies have cited the following corporate constitutional rights in numerous lawsuits: First Amendment, Fourth Amendment, Fifth Amendment, and the 14th Amendment. They also seek to take advantage of the Commerce Clause, the Contracts Clause, and the Supremacy Clause to avoid accountability. So by now, many of you are probably wondering, how did we get from a time when we ruled corporations to a time when corporations rule us? For the Constitution does not mention corporations. That's for starters. For the first 100 plus years of our history, corporations were strictly controlled and had no constitutional rights. Corporations couldn't even exist unless the state legislature enacted a piece of legislation called a corporate charter to create them. Without that, they couldn't exist. These charters were revocable and limited a corporation's lifespan and powers. They typically restricted corporations to a specific project, for example, building a bridge for the public interest, for the public good. Early corporations also had unlimited liability. There was no hiding behind the corporate veil. By contrast, today's corporations have perpetual life, limited liability, and are virtually unrestricted by charters which they can just get by filling out an application and paying a small fee. So now, huge corporations can do anything. They can, one of these mega umbrella corporations can sell insurance, drill for oil, make processed food, grow food, run media companies, you name it. So they can, they can have hundreds and hundreds of businesses under this one umbrella corporation. To top it off, the corporate constitutional rights doctrine has no legal foundation. It is based on false premises. The popular belief is that corporations became people by virtue under the 14th Amendment, by virtue of the Supreme Court's 1886 decision in Santa Clara County versus Southern Pacific Railroad. This is not true. I repeat, this is not true. The confusion arose from a court reporter's false, unofficial, post-decision comment that the court had given corporations 14th Amendment constitutional rights. Comments have no legal validity. They are a legal nullity. The court's decision made no such ruling. In fact, the court explicitly ruled that it would not decide the constitutional question because the case could be and was decided on other grounds. but the Supreme Court justices in later cases used the court's extrajudicial, unofficial comment as precedent for treating corporations as people under the Constitution, including the 14th Amendment. Bottom line, corporate constitutional rights were invented by the combined actions of one court reporter and later by Supreme Court decisions resting on this falsehood. The Supreme Court has perpetuated this false precedent without ever giving a rationale or justification for treating artificial entities as natural persons under the Constitution. So let me just leave you with some take-home points. Whenever a court decides that some statute or regulation violates some corporation's constitutional rights, it is a slam dunk. There's no discussion whether this is good policy or bad policy. There's no discussion of the enormous destruction that will be caused if the corporation gets to do what it wants by, claiming constitutional right to do whatever it wants. There's no consideration of any of this. It's just the court says, well, violates their constitutional right. Gotta let anything happen. Who, damn the consequences. That's it. So no matter what issues you work on, your reforms and the policies you want will be either watered down, overturned, or never enacted in the first place. And that's got to be frustrating, right? So a constitutional amendment, like the We the People Amendment, is the only way we can rid ourselves of corporate rule. We can't do it simply by passing a statute. I hear people say, oh, well, why don't we just pass a statute to overturn this? Well, that won't work. It won't work because the corporation will simply run to the Supreme Court and have that statute overturned as unconstitutional. So this tells you that the We the People Amendment is the reform that makes all other reforms possible. If corporate power is not controlled, corporations will continue to recklessly do whatever they can to maximize profits, even if it endangers the economy, the nation, democracy itself, and all life on Earth. So please, tell your neighbors and friends what you've learned here, and do what you can to support Move to Amend's project to get rid of this devastating corporate constitutional rights doctrine. And here's my little low-tech slide. I hope you can read it. Go to movetoamend.org and click on Learn, and that will take you to our dedicated page, which has our educational installments that our 3-member legal team have written. And, pass that on. I urge you to read those installments and also learn what you can do to support this cause. And I also would really appreciate it if those of you who can afford it would donate to Move to Amend. God knows we could sure use the money because we operate on a shoestring. So Move to Amends We the People amendment is the only one that restores the people's power to where it rightfully belongs. It will take a massive people's movement to accomplish our goal. And we need everybody to help in whatever way they can to rid us of this dangerous, destructive corporate rule. It's up to us. And before completely closing out, I just want to say that, the recent events that we've seen, this horrible pandemic and the horrible police brutality that's been going on for centuries, particularly against African Americans, has really laid bare the fact that our institutions are bankrupt and most of them are corrupt. So most of our institutions are not working for us. And please let us not miss this opportunity to bring about structural change, including getting rid of corporate constitutional rights, which really are one of the major root causes of what the destruction we see around us and the destruction of our institutions. So thank you very much for your attention, and I'll close now.
Thank you so much, Jan. And I believe people are going to want to ask you a number of questions. So I assume you're ready to answer questions?
Let me get a glass of water.
Okay.
Because I'm parched. Ellen, did you stop the recording so we can restart it during the Q&A? Like do a whole other recording? Because these